Hello, welcome to the ULV Justice Center. This is the pre-litigation module as part of our community law training series. In this video, I will be going through the fourth module in the pre-litigation phase, the legal analysis. In this video, I will be touching on the purpose of the legal analysis, the procedure for completing the legal analysis, as well as where this step fits into our litigation timeline. Specifically, I will be discussing the following issues: where the legal analysis occurs in the pre-litigation process, what the purpose of the legal analysis is, what needs to be accomplished during the legal analysis, how to file the legal analysis memorandum, and who to send it to, and lastly, what to expect after completing the legal analysis. Before I get into the material, I want to emphasize that the information provided on this site is not legal advice, but is provided for informational purposes only. If you are in need of legal advice, we advise you consult with an attorney. Before I get into the legal analysis itself, I want to touch on where the legal analysis is in the litigation process. Knowing at which point in litigation you conduct your legal analysis will help you understand its function. At this point, you should have gathered the relevant facts to your case, carried out a pre-suit investigation, and calculated the damages that you want to sue for. All of those steps lead up to the legal analysis and become a foundation for completing it. The legal analysis must be conducted before you move on to the last step in the pre-litigation phase, sending the demand letter to the opposing party. The legal analysis must be thorough because it is the last chance to decide if you think it is worth taking your case to litigation. Take your time with this step as you want to think it through carefully. The next topic I'm going to cover is the purpose of the legal analysis. The heart of the legal analysis is research-based, focusing on application of the facts of your case to relevant legal theories. The purpose of the legal analysis is to evaluate the case based on the relevant law and the cost of doing litigation. It allows you to evaluate the strength of your case before starting litigation and create a strategy for moving forward. Since litigation is a lengthy procedure and can be a huge financial burden, it is very important to weigh the likelihood of success against the costs and the potential awards available if you win. To conduct a legal analysis, you should write a legal analysis memorandum. Writing the memorandum is important so you can have a hard copy of the analysis for you to use as you progress with your case. If you do not do this step, then you will not have a good understanding of the relevant law that will help you in arguing your case. You will also not have a strategy for managing the costs of litigation. The next topic I will discuss is the step-by-step procedure for completing the legal analysis. This includes the issue, relevant facts, legal research, analysis, and conclusion. Remember that this legal analysis should be done in writing in the format of a legal memorandum. If you need a guide on how to format a legal memorandum, go to ulvjusticecenter.org and under Important Legal Documents, go to How to Write a Legal Analysis Memo. I have provided you with a legal memorandum template on the same page you access this video and worksheet, titled Legal Analysis Memorandum Template. Okay, so the first step of writing the legal analysis memorandum is to lay out your issue. This is commonly called an issue statement. The issue statement is the heart of your case and it includes the applicable area of law, such as California law or criminal law, the specific cause of action for your case, such as assault, and finally, the relevant facts that prove the cause of action. The issue statement should be posed as a question. It is the specific question you are asking about your case. The issue statement should be formatted like this. Whether under insert applicable law, it is your cause of action. When, state the relevant facts. An example would be whether under the California Civil Code, it is assault when a person threatens another person with a knife but does not physically injure them. This issue statement states the applicable law, the California Civil Code, states the cause of action, assault, and then states the key facts. A person threatened another person with a knife but did not physically injure the person. This is the basic format of an issue statement and will help you direct your legal research. The next step is to lay out the relevant facts of your case. You should have completed the facts gathering stage at the beginning of the pre-litigation phase, and after doing an investigation and statement of damages, you should have a good understanding of which cause of action you are basing your case on. The relevant facts are the facts that will help you prove your cause of action, so you should be looking for facts that match the elements of the cause of action you chose. If you are not sure what the elements of your cause of action are, you can find the elements of most causes of action using the California jury instructions, available on the California Court's website. The best way to make sure all the relevant facts are included is to make sure that each element of your cause of action is matched with the fact of your case that proves that element. The next step is to do legal research. This is broken up into two sections: rule of law and relevant judicial decisions. The two sections should be laid out together under the rule of law section of the memorandum. The first part of doing legal research is to find the statutes that apply to your cause of action. It is very important at this stage to already know exactly what your cause of action is. You can have more than one cause of action, but that will require a legal analysis for each one. So you should find the specific statutes that cover your cause of action and begin to make a list of all the relevant statutes you find. You should continue to update the list as you do the research. The best place to begin looking for relevant statutes is Google. A quick Google search for your specific cause of action in California will generally give you a starting place, or at least an idea of what code you should focus on. You should format your search like this: California, and then your cause of action. After this, the best place to go is the California Legislature website to do a code search. The relevant California code will depend on the cause of action for your case, but some examples are the Penal Code for criminal law, Civil Code, Labor Code, and the Family Code. Find the relevant code for your case and search for your cause of action in that code. Once you do that, you can start to look for any relevant cases. The statutes that you find, along with relevant court cases, should go in the Rule of Law section of your analysis. Next, you should research one or two relevant judicial decisions or court cases with the same cause of action, similar facts compared to your case, and where the outcome of the case is in your favor. These cases are called similar cases. Along with the two cases that rule in favor of your case, you should also find one or two cases that have similar facts, but where the outcome favors the opposition in your case. These facts are called different cases. The reason for this is so you can understand the legal trends the court used to rule against your issue, as these will most likely be the counter-arguments your opponent will use. A good place to start researching California court cases is Google Scholar. Not only is Google Scholar free, but it also has a California case search option. When researching cases, the most efficient way to search is to include the cause of action and distinguishing facts of your case in the search engine. An example would be if the cause of action is assault. You would put assault case, no physical injury. It includes the cause of action and a distinguishing fact of your case, which is important because you want to search for cases that also have that distinguishing fact. A good way to find the important cases for your cause of action is to look at what cases are being cited in the cases you do find. Those cases being mentioned in other court cases will generally be important ones for your case. Once you have the relevant court cases, add them to your Rule of Law section along with the relevant statutes. The next thing to do is analyze them. The next step is to do the analysis of what you have found during your research. This is broken up into two sections: case analysis and application of the law to your facts. The two sections should be laid out together under the analysis section of the memorandum. First, we have the case analysis. Once you have the two similar cases in favor of your case, and the one or two similar cases that are counter-arguments to your case, you should analyze them and break them down. The best way to do this is to do a mini case brief of each one. You can find instructions on how to do a case brief under the How to Brief a Case page on the ULV Justice Center website. As you do this, you will start to notice trends in the legal theories used by the courts, as well as important court cases governing the issue. When briefing the cases, you should point out if there are any key factual distinctions or similarities between the similar case and yours. These facts should be the ones that convince the court to decide one way or another. Generally, these facts will be mentioned by the court in their analysis. You should also focus on the statutes and judicial decisions the court bases their decision on, as these will most likely be the laws that you should focus on in yours. In the analysis section of the memorandum, you should analyze the relevant court cases you found, and you should divide the section up by similar cases and different cases. In this section, just analyze each case on its own, laying out the facts, relevant law, analysis of the court, and the conclusion the court comes to. Additionally, include why the case is similar to your case, and after this, you should move into the application section. In this section, you should apply the relevant law you found to the facts of your case. You should break down the relevant statutes and apply them to your case, showing how the facts of your case relate to the statutes. The bulk of this section will be comparing your case to the similar court cases you found, explaining why your case is similar to each one. You should explain what facts are different and what facts are similar, and analyze why the court would rule in a similar way in yours. You should also analyze the counter cases and analyze the facts that are similar and the facts that are different between your case and the counter cases. You should analyze why the court ruled the way they did and apply that to your case so you can understand the counter arguments that could be made against your case. This is the heart of the memorandum, as it is where you form the basis for your case and decide what laws and legal theories you will use to argue your case. This is the last section of the legal analysis memorandum and just simply includes the legal conclusion you came to based on your legal research and the facts of your case. The structure of this section should restate your issue statement, but instead of using the term whether, you should simply use it is or it is not. To use the example mentioned above, you would say, under the California Civil Code, it is assault when a person threatens another person with a knife, but does not physically injure them. That concludes the procedural steps of completing the legal analysis memorandum. Next, I'm going to cover the administrative aspect of the legal analysis memorandum, such as what to do with it when you finish and what to expect moving forward. First, it is important to know what you should do with the memorandum after you complete it. Do you send it anywhere? Do you file it with the court? Actually, this document does not get sent anywhere, as it just stays with you. If you are not represented by an attorney, do not share this document with anyone, as the other party might be able to get it if they subpoena it from them. You should keep it filed somewhere safe, and you should make several copies. It is a good idea to have several hard copies too. Do not only store it on your computer. You should complete the legal analysis as soon as you can. You should be completing the memorandum while you are doing research and as you organize your results. As you continue to do legal research, you should continue to update the memorandum. After you complete the legal analysis, the next step is to prepare the demand letter to send to the opposing party. The demand letter summarizes what you got from the legal analysis regarding the cause of action you want to sue for and what damages you are seeking to recover. Once you notify the opposing party with your demand letter, it is time to begin preparing your complaint. This has been an overview of the legal analysis, which is the fourth module in the pre-litigation phase. For more detailed information on the legal analysis and the pre-litigation phase, go to ulvjusticecenter.org and under Community Law Training, find Module 2 and go to Legal Analysis. If you have any questions regarding the pre-litigation module or need clarification on anything you just heard, you can always email us at ulvjusticecenter@gmail.com. Remember, this information is not legal advice and should be used for informational purposes only. If you are seeking legal advice, you should consult with an attorney. On behalf of the ULV Justice Center, we thank you for your time and hope you found this video helpful in your legal matter.